Good morning. My name is Jeff Vernon, and I'm here to present my work here, the fertility frontier, or the regulating reproduction. And a word of caution before I begin. The title is somewhat deceptive, a historical analysis of the legal approaches to advances in assisted reproductive technology. When I was writing this as kind of a summary of my dissertation, and what happened is it became less historical and more policy-based. I'm an interdisciplinary person by nature, and so I combined law and history together. So it became a little bit more law-focused and policy-focused than history. I would also like to thank the conference organizers and my fellow panelists. It's really been illuminating so far and really some rich material. In 1973, Dr. Landrum Shettles of Columbia Presbyterian Hospital in New York City agreed to assist a couple who had struggled for years to conceive a child. John and Doris Delzio came to Dr. Shettles, a recognized expert in the emerging field of in vitro fertilization, in order to attempt this final experimental procedure in the hopes of overcoming infertility and having a child. The Shettles started working with the Delzios and even got as far along as fertilizing Doris Delzio's eggs in a laboratory. However, the hospital administration learned of Shettles' research and halted the experiment before the fertilized egg could be reimplanted. By terminating Dr. Shettles' research, the hospital administration impeded scientific progress in aiding infertile couples. Moreover, the discontinuation of the procedure personally devastated the Delzios, who became emotionally connected with the possibility of experiencing parenthood. As a result, the Delzios filed a lawsuit against Columbia Presbyterian Hospital. In their lawsuit, the Delzios alleged that the hospital's termination of the procedure provided the basis for legal action under a claim of intentional infliction of emotional distress. The Delzio case illustrates a complex environment and difficult issues associated with advances in biomedical research and emerging medical technology. The difficulty connected with understanding and addressing the issues and dilemmas presented by the rapid advance in biomedical technology has facilitated the creation of an innovative field of scholarship called bioethics. One of the most complex issues discussed today in the field of bioethics is the regulation of human reproduction and fertility. In many ways, fertility treatment is located just beyond the water's edge, beyond the boundaries of legal directive. It is at the frontier of human knowledge, medical science, and moral understanding, and the law. Currently, much of the scholarly debate surrounding advances in biomedical technology has centered on the value of applying legal solutions. However, instead of discussing whether the law should be employed to regulate biomedical advance or fertility treatment, it is more informative to analyze the choice of substantive law. Substantive law creates the legal rules that direct the relationship between individuals and society and/or between the individuals and the state. Substantive law contains a number of varied and diverse bodies of law, including contract, tort, administrative law, criminal law, and constitutional law. Some bodies of law sweep more broadly than others. In other words, choosing particular areas of law to apply to any given issue impacts the reach of the court's decision or the effect of that law. The most extreme solution with the greatest reach and the greatest impact is the application of constitutional law. I posit that private law rather than public law, particularly in the areas of contract and tort, is in many instances better equipped to resolve the diverse and complicated issues presented by advances in biomedical technology, principally in the area of fertility treatment. The historical record demonstrates that solutions applied by legislators or constitutional interpretation can fail to permit the flexibility required to effectively balance the competing interests inherent in the rapid changes associated with biomedical research. Public law is a term used to describe laws and regulations that control the connections between individuals and the state. Public law includes several different categories of law. These categories include criminal, administrative law, and constitutional law. Cases speaking directly to constitutional principles are sweeping mandates, directing the choice of public law to resolve contentious issues such as abortion. Criminal law offers an important area of substantive law. One of the most effective ways to stop or at least deter behavior is to make it criminal. Legislators and Congress assign criminal punishment to acts that bear moral culpability, Statutes reflect the moral values of society and reflect the values of the legislators who enact them. Public law represents an important facet of substantive law, but is only part of the overall landscape. Alternatively, some bioethics issues have been dealt with through private law. Generally, private law does not involve the state. The two primary examples of private law is the law of contracts and the law of torts. Contract law involves a legally enforceable agreement between two or more parties. Under a contract, the parties have exchanged promises, creating a legally enforceable agreement whereby a court may offer a remedy to an aggrieved party if a breach occurs. An individual commits a tort when they commit a wrong that breaches a duty owed to another individual. Courts may rectify these wrongs by awarding damages to the harmed individual. What's important to note here is that private law often proceeds on a notion that case decisions reflect the values of the community and allow for incremental change desired by the community members. Private law assumes individual autonomy and the need for a case-by-case analysis. And here you'll see just a reflection of essentially what I've summarized so far. You can ignore the relative values assigned here. It's more of just representation. When you apply public law solutions, such as constitutional law, you see often that it creates greater consistency. It has a broader impact. States and courts have to follow those principles. But you lose flexibility. And private law offers somewhat of an alternative, an inverse to that. Curiously, historians have largely focused on one piece of the human reproduction equation, preventing or terminating pregnancy through either contraception or abortion. Under a related analytical framework, historians have also explored the issue of eugenics. However, little work has been completed on the efforts to facilitate procreation and the arrival of fertility treatment, which has rapidly advanced since the 1970s. This represents a large gap in the historical literature and a gap that I fill with my dissertation. Moreover, it is essential that scholars research and understand how society has responded to the continuously developing field of assisted reproduction, because it allows for a more accurate representation of the rights associated with procreation. Even Roe versus Wade, a landmark case supporting the woman's right to choose to terminate her pregnancy, has important implications and connections with facilitating pregnancy. The Supreme Court's rationale has been cited often in expanding the right of privacy to protecting the right to procreate. But what kinds of issues do advances in fertility treatment create? The following slides offer a sampling of some of these issues. Some technologies offer comfort and predictability. For example, genetic counseling helps couples determine if genetic diseases could be passed to potential offspring. While this reassures couples that their children will not likely suffer from a genetic disease, it produces ethical and moral questions. If applied to traits or phenotypes rather than genetic diseases, the use of genetic counseling can push the boundaries of eugenics. Generally, eugenics advocates the use or practices aimed at improving the genetic composition of the human population. Genetics can be either positive or negative. Positive eugenics is aimed at encouraging reproduction among the genetically or the perceived genetically advantaged, whereas negative eugenics is aimed at lowering the fertility among the genetically disadvantaged. The law has addressed the issue of eugenics in a number of cases. Buck versus Bell and Skinner versus Oklahoma are two examples. Buck versus Bell is a Supreme Court case which upheld a statute instituting compulsory sterilization of the unfit, including the mentally challenged, quoting, "for the protection of the health of the state." In this manner, it may be seen as an example of negative eugenics. In Skinner versus Oklahoma, which is another Supreme Court ruling, it held that compulsory sterilization could not be imposed as a punishment for a crime. Another issue to be explored is the use of fertility treatment to realize gender preference. Many couples from varying cultures and countries now desire to determine and select the gender of their child. This preference is, of course, a product of a number of factors in which I don't have time to discuss today. But new fertility technologies have now allowed scientists to increase the chances that a child of a particular gender will be conceived. Most recently, this is seen in microsort technology, which allows researchers and scientists to separate sperm based on gender. X chromosomes actually way more than Y chromosomes, and using fluorescent dye allows them to separate these or the sperm, and then use in vitro fertilization to implant only one or the other. One final example is the issue of class and access to fertility treatment. Fertility treatment is extraordinarily expensive in the United States. The average cost of one cycle of IVF alone can be $11,000. Multi-cycle treatments can be $36,000. And if a couple requires a donor egg in connection with the IVF treatment, it can be as much as $28,000. And as previously noted by Emma, the surrogacy cost can be as much as $60,000 to $80,000, and I've seen it go even higher. So only those who have financial means or insurance may be able to afford fertility treatment. Insurance providers vary as to whether they cover the practice, and currently only 15 states mandate insurance providers cover the cost of fertility treatment. Even then, the types and the amounts of coverage vary. Moreover, the issue of surrogacy and egg donation in particular presents the question of exploitation. Often egg donors or surrogates are either college students, this is in the United States, or fall into the lower middle class or below income brackets. Wrapping up, Roger Dworkin, a bioethics scholar and law professor, and my mentor when I was in law school, suggests that the law is an important facet, and it can be used as a valuable tool to resolve disagreements in the field of bioethics. However, he also cautioned that blind faith in the law's ability to resolve bioethical problems or unthinking acquiescence in the dominant role of law would be unsound. Dworkin argues that law is a limiting or reactive factor, rather than a positively acting forward-looking force. And as a limiting factor, law should only be used when imposing limits. In summation, my dissertation will demonstrate that private law rather than public law, particularly in the areas of contract and tort, are in many instances better equipped to resolve the diverse and complicated issues presented by advances in reproductive therapy, principally in the area of fertility treatment. Moreover, the historical record substantiates that solutions applied by legislatures or constitutional interpretation often fail to permit the flexibility required to effectively balance the competing interests inherent in the rapid changes associated with biomedical research. In this way, the law and the legal system should tread gently, walking up to the water's edge and waiting before merging itself in the water. And that is my presentation.